Hey everybody, this is Nafiz Ahmed. I'm a criminal defense lawyer in Redwood City, California, and I'm coming here today to let you know about some big changes that are on its way, and it's probably being implemented right now as we speak in many courts across the state of California. Just this past April 6th, the California Supreme Court adopted some amendments to the rules of court, and this is going to impact defendants in that if you're in custody for a criminal offense, or if you've been recently arrested and are currently in jail because you're awaiting, charges to be filed, there's going to be a big change into the release procedures. Previously, these defendants who have been in custody would have to post money bail in order to be released from the jail. And the California Supreme Court has changed that for a lot of case types. There's going to be some exceptions, but for most felonies and most misdemeanor offenses, this is going to be the quote-unquote get out of jail free card. There's going to be a zero money bail that's going to be required of a defendant to be released from the jail so that they can return back home and be with their loved ones and work while they either await the filing of criminal charges or if they were in custody fighting the charges before they're released, they're going to be released home on zero bail so that they can, handle business while they're out of custody. This is a huge change, and the way that the bail system used to work is minimum bail usually in most counties on a felony offense starts at least 10 grand. Going through a bondsman, you're going to pay a percentage anywhere between 7 to 10% of the bail amount. And when you deal with multiple felonies, that amount usually gets much higher. So this is big news for defendants because it's going to allow them to be out of jail without having to spend money to get out. And I think that's a great relief. If I haven't said this already, this relief is going to be in effect starting April 13th. Each county in the state of California is supposed to adopt this new emergency bail schedule. The courts have already started adopting it, and it's supposed to be in effect for a period of 90 days after the governor declares an end to the Covid-19 pandemic that we're facing, or end of the emergency orders that are in effect, okay? So this is going to be in place for at least 90 days and maybe, a month or so longer, who knows, okay? So that's big, big news. The other thing that's big news is for those defendants who are already out of custody and you're wondering, well, gosh, how does, this all help me? There's different stuff that's gone into effect that, will be helping you. For example, you're going to be allowed to appear in court without having to show up. And that's, of course, going to require that the technology be available. But the technology that the Supreme Court is discussing is video and or telephone, okay? And everybody, most courts should have at least a telephone in their department. And so what this means is that for each courtroom that has at least a phone available, a defendant should be allowed to appear telephonically without having to show up to court. The lawyer for the defendant can let the court know, hey, my client consents to this procedure, waives his or her right to be present, and now the defendant doesn't have to show up. There used to be strict rules about having a signed document, specifically signed in court, that the defendant gives up the right to be present, but now that's being relaxed. And so long as the defendant tells the attorney, I give up my right to be present at this particular proceeding because I don't want to show up to court and risk being infected with the coronavirus, the court is required to accept that. So that's big, big news, okay? There's one thing I want to go back to you about with bail, okay? When I talked about exceptions, I didn't mention to you the people who are not going to be affected by this emergency order, giving zero bail for these defendants. And this is for the folks that you would kind of figure, individuals facing serious charges. We're talking about strike offenses, either serious felonies or violent felonies, okay? Most of the clients that, I represent who aren't going to be affected by the zero bail are going to be those individuals charged with driving under the influence, that whether that be alcohol or drugs, any type of DUI, okay? Whether it's a DUI or a domestic violence case, the new emergency order of zero bail does not apply to you. Okay, so you're still going to end up having to post bail if you're arrested for domestic violence to get out of jail. For most first-time offenders for DUI purposes, okay, a lot of counties are not having these individuals post bail to be released from jail. It's usually only if you're dealing with a felony DUI where there's injury, or if that means that there's 4 or more DUIs in 10 years, that these individuals are going to be having to post bail. But any DUI, let me say that clearly, any DUI, the court is not obligated to let you out without bail. You're still going to have to post bail if that's what your county's doing. Okay, but again, that usually only applies when you have 2 or more DUI offenses. There's a lot of big stuff going on right now. I'm happy to explain it to anybody who wants to give me a call. But talk to your lawyer. Given all the changes that are going on, and they're going on quite frequently, you're going to need to know your legal rights and to make sure that your lawyer has you taken care of. So give your local attorney a call, and I wish the best to all of you.